So this morning, our social media team is asking you, how do you say good morning in your language? And I see Obed Saka Okindo says, Bwakire buya. Mchikeyo.
Why do I get the impression that you're speaking a distinct language that comes from the western part of the country? A place called Nyanza, a place called Kisi. Am I close?
Yeah, I think so too. I'm not sure, but I think so.
We're going to have to ask our guest how
Bwakire
he says good morning
buya.
in his native tongue, so to speak.
Galana says, Lamukadze.
That much I know.
Which one is that?
Umemkaji. Yes.
And that is which language?
That is the Kigiriama or the Kidigo or Kidruma. They are very similar. Actually, what am I saying? The Mijikenda more or less say good morning in the same way. Yes.
So Galana says he comes from Giriama,
Yes.
so that's his Lamukadze. Yes.
Umemkaji.
How do you say good morning in your language? Ndu.
Sorry?
How do you say good morning?
Kedu.
That's it.
Yes.
Why do you people specialize in summer?
Kedu, how does Kedu mean to say good morning?
Okay, that's a short form. Kedu Kodi. So now you're asking, it's not about the time of the day, but regardless of what time you're asking, how are you? How are things? Is it?
It's the African greeting, which is never really hello.
And it's not subjected by time. It's about the state of your being.
As how are you and all that you represent? Okay.
Our friend in Uganda says, Wasuze Otia. Nakibuka Juliet says, that's Buganda. Okay. Let's first hear the day's proverb before we introduce our guest.
Mchovya asali, hachovi maramoja.
Mchovya asali, hachovi maramoja.
Hapana.
Kwa Kizungu?
When one dips their finger into either, now this is my addition to it, either the honeycomb or the honeypot, they do not dip the finger only once.
They find the sweetness and they continue.
Yes. There's a repeat action that is likely to follow.
Right.
Yes.
Welcome to our audience on KTN Home who join us for the next 1 hour. We will be live on TV in addition to being live on SpiceFM and online. SpiceFM KE, YouTube, Facebook and Twitter. Our guest today, #Justice Thursdays, is a judge of the Supreme Court of Kenya. The Honorable Justice Dr. Smokin Wanjala. He's in the studio. Good morning, Judge.
Good morning.
Karibu sana to the Situation Room.
Asante.
We call this the hot seat. It's raised like the bar. You're used to being at the higher level, and you look at the people below, and from the bench to the bar. So this is just similar. It's just that we are only 4, not 7.
Yes.
Welcome to Kenya's biggest conversation, Judge.
Thank you. Thank you.
You're also the director, and recently took up this position, director of the Kenya Judiciary Academy.
Correct.
So what's that?
The Kenya Judiciary Academy.
Yes.
Well, the Kenya Judiciary Academy is now what we can call the successor to the Judiciary Training Institute. The Judiciary Training Institute, therefore I must talk about the Judiciary Training Institute. Because the Judiciary Training Institute was established through what I can call administrative fiat or edict by the then Chief Justice, the late Evans Gisheru, with a view to really harmonizing and promoting the continuing training of judges, magistrates, and judicial officers, and therefore to enhance their effectiveness in administering justice. Therefore, it's a learning institution for judges. You may want to know why that was necessary, but in brief, that is what it was meant to do. And now it's been succeeded by what we are now calling the Kenya Judiciary Academy. I'm sure I'll have a couple of minutes to answer why the transition from the institute to the academy.
Those minutes begin now.
Right. Well, as I've said, the Judiciary Training Institute was meant to provide training to judges and magistrates and other judicial officers to enhance their effectiveness in the administration of justice. What the Institute then was supposed to do is really to come up with customized courses, or you can call them refresher courses, to afford judges and magistrates an opportunity to refresh their understanding of the law as it is in terms of legislation and in terms of precedent. Why was that necessary? That became necessary because although the perception among the judges and the magistrates was that there's nothing really they were supposed to be trained in, because judges are supposed to know it all.
Sure.
And therefore, initially, when the institute was established, there was some latent resistance to that idea, because the issue was, why would you train a judge?
And who's this who's training
And
a judge?
who is this who can train a judge? Because the judge is the oracle of law, the oracle of legal knowledge. But then the reality was to the contrary. At law school, a law student is never prepared in all areas of law. There are certain areas of law which you never come in contact with when you're at law school. But when you're a judicial officer, a magistrate or a judge, disputes will come before you relating to that area of law in which you are not familiar, or with which you're not familiar. And therefore you cannot expect such an officer to render justice from a point of ignorance. And therefore the Institute was supposed to replace that gap, okay, or cure that gap. And since 2008, I think the Institute has performed fairly well in keeping judges abreast through these short courses. For example, if you did not take an elective like insurance law or company law, and you are a judge heading the High Court division, commercial division, you must really know the substance of the law.
Right.
Therefore, you go back to the Institute and you're taken through just those basics, because you're already a lawyer, you're already a legal practitioner and technocrat. So you're not going through a school, but you're just going through the technical aspects of that body of law to keep you acquainted. So that basically is what the Institute has been doing.
Justice,
No,
Yes.
please do go ahead.
were there certain things, or was there a time where there were certain occurrences in the country that then led to the establishment? Thus, because oftentimes we see that, all right, things may have been happening in a certain manner, which then gave birth to the need to have something like this established. Or was it just the realization that there were certain gaps in the process of judicial operation that then needed this?
I think it was a combination of both. First, the realization came about when quite a number of decisions from either the lower courts were being overturned at the appellate level. Let's say the magistrates' decisions being overturned by the High Court sitting in its appellate posture, or High Court decision being overturned by the Court of Appeal. And then the grounds of overturning such decisions were revolving around the judge's understanding of the technical aspects of the law. And therefore, the appellate judges would say, if you had understood that this is the law, you would not have arrived at the decision at which you did. So therefore, that was a realization that there were glaring gaps in the manner in which judicial officers were handling disputes before them. But then also, judicial education had become internationalized. In this part of the world, it is still in its infancy. And through best practice learning, I don't want to talk about benchmarking for obvious reasons, but through best practice learning and through the vision of the then Chief Justice, it was felt necessary. And of course, in consultation with the judiciary leadership, it was felt that time had come for us to refresh to go back and refresh. And if we were to make mistakes, let not be mistakes on our understanding of the substantive law, but perhaps let them be mistakes of our appreciation of the social context of law. And therefore, that was the gap that was meant to be filled, hence the institute.
Do I get the impression from what you're saying that when individuals who have studied law at university go to law school, that some of these matters that you now speak of are merely touched upon and not in great detail?
That's partly true. That's partly true. When you go from the university,
Yes.
when you go to the Kenya School of Law, what you're now being taken through there is the process of law, how law interacts with humanity, okay? But at the university, you're being taken through the substance of the law. And then what do I mean by the process of law? Is if you are to take a plea, for example, from an accused person, what are the procedures? How do you go about it? How do you go entering a plea? This is just an example. So the Kenya School of Law really concentrates on now transforming you from a repository of legal knowledge to the process of law, how you are going to apply it. It may very well be that because of certain requirements, you did not take certain compulsory components of the law from the university that you graduated, okay? And therefore, you're required now to also take that substance, to be taken through that substance of the law. If you did not take a course in land law or the law of property in land from whichever university, you cannot practice in Kenya unless you are taken through that substance for obvious reasons again. And therefore, that's why I say it's partly true. So, but what you learn in substance at the Kenya School of Law, you do it not in an environment of a university. In an environment of a university, you think deeper, you critique, you engage in discourse. But at the Kenya School of Law, you are actually just being fed, the substance. And therefore, one is bound to have certain limitations, even as a judge, in terms of their comprehension of the substance of the law.
This leads me to this question. If that then is the case, and I look at what it is, for instance, the lower courts deal with, what the High Court deals with, courts of appeal, and then now to the office that you are currently constituted in, should they or does they exist, or the institute that you now head, does it then consider that at every stage, perhaps this refresher course you speak of ought to be introduced so that even as things move higher, laws change, because they do change.
Yes.
All these things are taken into account so that as these matters are taken up, as is the rights of every citizen, they are guaranteed that they will get the full benefits of it from people who have been adequately prepared.
Yes, and that's now the essence of continuing judicial education. That is the essence. The days when a judge was a know-all are no longer tenable. Such a situation is no longer tenable. And therefore, there's that need for continuing education for judges. That just as there is now continuing education for professionals in the entire legal profession. Lawyers, for example, have mandatory continuing legal education, which will determine whether their practicing licenses, for example, are renewed or not. Law is dynamic. It keeps changing. It keeps growing. And therefore, we must change with it. That is exactly the essence of the Judiciary Training Institute.
When it comes to the academy, is there anything that's going to be different then between the academy and the institute?
Oh, yes. So far, we have talked about the institute simply equipping or refreshing judges and magistrates in areas of law. Just law as it is, law as it exists in terms of legislation and judicial precedent, okay? That is the essence of the institute. But increasingly, things are changing. They're changing in that judges are now being faced with disputes for which there is no law, or for which there is inadequate law, or for which there is no existing judicial precedent. The challenges of the 21st century are throwing to the judiciary problems for which they may not have been prepared, even at university. And yet, when a disputant approaches a court, they want a solution. They want a resolution of their disputes. They want justice. But then they will not stand and say, the judges or the Supreme Court, was never prepared for this, so we must understand when they make mistakes. Not at all. All right, let's just...
It's all right.
Sorry about that.
No, don't worry.
Oh, no.
It happens to the best of us.
We do it all the time.
All the time.
The examples as you keep giving, I've just thought of one.
Yes.
Challenges of the 21st century.
Yes.
Where, for example, we acknowledge that there's going to be a whistleblower.
Right.
But then a whistleblower will use a secret recording device to gather the information and evidence against you.
Yes. Thank you. In fact, I was heading that way. What type of challenges, what type of disputes are coming before the courts at this age in time? There are challenges to do with, for example, technology, electronic evidence, for example. Let me pick it from there. How do you, as an offended citizen who has been defamed through social media, how do you go vindicating your reputation before a court when the evidence you seek to rely on is inadmissible in terms of the existing law? So you can see that there is a gap there. How should the court respond? Because the person who has generated that form of defamation has done it electronically. And he or she may very well have generated its disappearance, meaning that you cannot even present it before a court of law. We have issues dealing with terrorism. How do you treat a suspect on a terrorism charge? Do you treat that suspect as if you would treat any other suspect, perhaps suspected of stealing an egg or a chicken or a goat? Do you treat them the same level? You remember there was, for example, a case that really occupied the Supreme Court, the digital migration case. And I think when I say that, it touches you. Here was a case where the court was being treated to submissions that had no foundation in existing law, meaning that we had to go beyond legal phenomena to understand what was before us. It was no longer a question of disputes about frequencies and licensing. It came about a question of spectrum. There are many, many examples one can give. And therefore, the institute is not prepared to train judges in such challenges. Hence the academy, which is transiting the institute into something much more than a refresher course institution, into an institution akin to the university, but not a university for obvious reasons. An institution that now provides a forum for critical, not just for learning the substance of the law, but critical judicial thinking about emerging challenges, emerging areas of the law. That is the academy. The academy, therefore, is something that goes beyond refreshing the minds of judicial officers. It locates judges and magistrates in the middle of the action, in the middle of the action. How prepared are we? Yes.
Doesn't that mean then that it has to be then robust in the manner in which it operates? Because what you would be presented with today is not necessarily what then you would need a refresher or training on tomorrow. Because here we are in 2021 and a case would have come up and you've not seen anything like that before, for which you would need some kind of training. So it just means that there's an ever-changing refreshing that needs to happen, and you can't have like a set course, for example, like you would in a university.
Right. Correct. That's why now we are calling it an academy. an institution that provides space for that kind of ongoing discourse, for that kind of critical thinking, and for sharing, and for storing knowledge, and harnessing debates, so that a product of such an academy, a structured institution that continually equips a judge with emerging challenges in law, areas in law, a person like that will be more equipped. So we are thinking about critical thinking as opposed to the imbibing of legal knowledge on the basis of existing law.
So does it only deal with judicial officers, or are you going to extend this to other cadres of the judiciary?
The academy will actually be it will be an expanded institution, because we don't want that silo mentality of training our judges for their judicial duty. Remember, judges are just but one aspect of the players in the entire justice sector, and therefore it will be a forum where all other players in the justice sector are brought on board to enrich this discourse.
Because now I am thinking DPP, DCI,
Right.
those ones as well, the correctional officers, whether they come in anywhere at some point, and then ordinary citizens, whistleblowers. Okia Omtata, should he be admitted to this judicial academy, sponsored free of charge by the citizens of Kenya? We are talking about the future of judicial training in Kenya. Our guest this morning is the Honorable Justice Dr. Smokin Wanjala, Judge of the Supreme Court of Kenya and Director of the Kenya Judiciary Academy, being hosted by Eric Latif Nduoko and C.T. Muga, who incidentally is also a friend of this other Supreme Court judge. I mean, C.T., surely now you qualify to be the Chief Justice at this rate.
Or the chief criminal.
Oh, all that.
By the time you get to know officers with such high ranking, you must ask, what did you do wrong?
Mr. Jump through some hoops. At some
You know
point.
what they say, show me your friends and I tell you what kind of character you are. I mean, you're friends of Supreme Court judges.
And as I've told you before, they were not always Supreme Court judges. Yes, there was a time when they were regular human air-breathing beings.
And now they're not air breathing.
No, they are rarefied air-breathing beings. Yes.
Okay, you've got a question for the judge.
Yes, I do. You see, as we're talking, something came to mind. Sometimes the course of this year, we're in 2021, are we not? The president inaugurated and gave charter to a certain university, a very critical, a very interesting one. I'm going to stop there and go back. It's called National Defense College. Now, National Defense College was a college that didn't just deal with people who were in defense, senior civil servants.
Yes.
But what was interesting about it was that other people who were of similar seniority across the continent and even the globe came to that particular college. But then it was now given a charter. Now, when it was given a charter, now that's when I didn't know this, but I was pleasantly surprised, because now the charter making the university, it now encompassed many other institutes also. And I just want to read so that you understand how many there were. I didn't even know some of these colleges existed. For instance, Kenya Military Academy, I didn't know it existed. Defense Forces Technical College, I didn't know it existed. The International Peace Support Training Center, did you know it existed? The Ministry of Defense and University Colleges in Defense and Security Studies, did you know it existed? Now, all these things were brought in. Now, if the same caliber of civil servant or senior individual in their places of work are part and parcel of this, I was thinking now, when the judiciary have a college, they have an academy, and they take it further. And other people who are beyond the judiciary are invited. And I was thinking, what a wonderful institution that would be. Because then you'd not only put a human face to the judiciary, but people who are in decision-making positions within the country will have had a very close touch with the laws of this country and the understanding of how it actually functions.
And the importance of obeying court orders.
Your thoughts, Justice?
Yes, precisely. And that's why we are transitioning now from an institute to an academy, because of the remarks I made earlier. First, I must point out that the institute was established before the promulgation of our 2010 Constitution. So therefore, and that's why it was established through administrative fiat. But the Constitution, the 2010 Constitution, places a premium on the need for continuous training and continuing learning of judges and magistrates and other judicial officers. And one of the mandates of the Judicial Service Commission is to facilitate those kinds of programs. Actually, the Judicial Service Commission is the one mandated to facilitate the continuing learning and training of judges and magistrates. So therefore, the Constitution already places a very high premium that learning is a value and is an asset for the dispensation of justice. You will never dispense justice from a point of ignorance or small learning. Now we're talking about big learning, which means therefore, and the Judicial Service Commission has delegated that responsibility to the Institute and now the Academy. We have in place a new Chief Justice, beginning with the Chief Justice Emeritus, Dr. William Mutunga. We've had a situation where now incoming Chief Justices start off by giving us their vision, laying out their vision for the Kenyan judiciary. And successively from William Mutunga, Justice Maraga, and now Chief Justice Martha Koome, we've had succession of visions. But it all started with that judicial transformation framework, of which I was a part in formulating. Now, it means, therefore, that the content and methodology and the end product of training of judges must change to respond to the challenges of the 21st century. It also means that the Academy as an institution must broaden its wings to incorporate other actors in the justice sector. The office of the DPP, for example, which is a critical component in the administration of justice, the Children's Department, probation, the CID, all law enforcement agencies interact with our courts. And sometimes there is a disconnect in that interaction, which leads to a fallout and which leads to a perception that perhaps the judiciary is a weak link, for example, in the fight against corruption. You've heard those claims.
Yes, we have.
But that is occasioned by that disconnect. And to deal with that disconnect, we have now this academy where it will bring together all these institutions, the Ethics and Anti-Corruption Commission, a vital law enforcement agency. But it is a law enforcement agency which must prove its case in a court of law. And therefore, the Academy offers a forum for this exchange, for this learning, so that judges will know the mind of a prosecutor. Because the prosecutor will come to court saying, I'm not looking for a conviction. I'm just looking for a dispensation of justice. But for a prosecutor, if you don't secure convictions on a regular basis, then that means there's something wrong with the way you're presenting your evidence. Or perhaps the courts are not appreciating adequately enough. And vice versa. Let prosecutors, let all other actors, let lawyers, senior lawyers who now are interacting with courts understand the thinking of a modern judge. It is no longer a question of, oh, this is the dispute, this is the applicable law, this is the precedent, and that's the decision, or this is the ratio decidendi. It's no longer that rigid. When you look, and I'm sure you have been reading judgments that are coming from our courts, right from the High Court to the Supreme Court, they are a little bit different from judgments of old. There is an aura of theorization if you look at the body of the judgments. And therefore, the Academy is supposed to accentuate that kind of judicial posture. Yeah.
Does the Academy take into consideration also the conduct of judicial officers? There have been perceptions, alleged, imagined, or otherwise, about judges and judicial officers engaging in misdeeds, corruption,
Yes.
etc., etc. There's been
questionable activities.
Indeed,
Yes.
there's been a smear on the
Right,
image, and
right.
it continues to be in the minds of the general public.
Yes.
Does the academy, or would it in future, currently or otherwise, take this into consideration and say, look, this is something we also must then continue to keep abreast of and train ourselves in, frown upon as a fraternity?
Oh, yes. In fact, it's not a question, it's not a futuristic issue. Right from its institution, both the institute and now the academy have placed as one of their core courses the Judicial Code of Conduct and Ethics. And quite recently, in fact, I just opened a training of magistrates on challenges, ethical challenges for magistrates at the workplace and beyond the workplace. And it was a very interesting discussion. That what we do is to make sure that we equip anybody who intends to join the judiciary with the code of conduct, knowledge of that code of conduct, because it's the Bangalore principles are there for everybody to see. What the do's and the don'ts are there in black letter. But we also have day-to-day challenges, ethical challenges that face judges and magistrates at the workplace and beyond. And the work of a judge is not very attractive because you are not just judged by society when you are sitting on that seat of justice. You are judged by society even when you're just leading a normal life. Even if you just start walking across the road, if you are not in sync with what the public expects of you in terms of how to walk, they say, look at that guy.
And
yet he's a judge of the Supreme Court of Kenya. Look at how he's walking. He's wearing a jeans. So you are supposed, even during summer, to maybe walk in a robe. So we actually take that training very seriously. And part of what the academy does and shall continue doing is during the induction of incoming officers, and also not just judicial officers, but judicial staff, all the staff that offer support, administrative support to the judges, including our legal researchers. They must be taken through the content of that code of conduct, because they must know that their own conduct could very well affect the office of the judge who they are rendering support to. So for us, that's a critical component. And we shall continue asking, how do we then interact with society? How do we live a normal life and yet retain that title of a judge of the High Court of Kenya? How do we balance? How do we navigate? Those are questions. That
do you think it's an unfair expectation of the society to look at you as a judge of the Supreme Court and expect you to live a life that is slightly different from when you are not a judge?
I think maybe it's not necessarily unfair, but it's the way the society has been groomed, attuned to look at a judge. And the academy is going to demystify that. It's going to demystify this hallowed perception of a judge as if you're superhuman. The academy will also seek to cause an interaction between citizens and the judiciary. For example, we are thinking of a situation where when we are now built up as an institution, as of now, we are really what we call tenants, or tenants at will. We have no physical abode that we can call our own. We are tenants at will of government agencies. We don't have physical structures of our own. But fortunately now, the government has finally allocated a piece of land where the academy will be constructed. When the academy is so constructed, it shall not be constructed to look as a court. It shall be constructed to look at as a center of excellence for judicial training with the ultimate output of real justice to the Kenyan people. And therefore we shall have even theatres, lecture theatres, where students, not just of law, but students right away from primary school can come in and be given a window into which they could peep to see the workings of the law, the workings of the courts. So it is something much bigger than just training judges. And therefore they will be able to ask questions. And through that interaction, judges will be able to explain themselves.
Right.
And society will also be able to explain itself why it seeks to be more exacting when it comes to judicial officers and not politicians, for example.
Don't you think, though, Justice, even as we look at it, because don't you think, though, that this hallowed space or this hallowed place, because should actually be the preserve of judicial officers and others in the country, because it's to you that the rest of the society comes to and says adjudicate over 1, 2, 3. It's to you that you come to and say make a ruling over this thing, whether it's a moral, ethical, or commercial issue, whatever it is, that you then take the decision over this, because not everybody can come into this place, into this fraternity. Not everybody is chosen to be here. Isn't it a place? That's why, should there be a smear on the image of any judicial officer, it's such a big thing, because it is a reserved position.
Well, if we look at it that way, maybe, but that ought not to be the situation. A court of law is not some kind of holy temple or an altar which must be revered. A court of law should be viewed as a place to which afflicted citizens, those people who seek justice in their day-to-day existence, can run to. And therefore, if you make it a hallowed place, they will not be able to run to that place. And that's why I'm saying we are trying to demystify that perception of the judiciary. The judiciary is supposed to render service to the people.
Should be open and accessible.
It should be open and accessible while maintaining its hallowed status. But it should be accessible.
So how do you balance those two, Judge?
And
Because there's that openness. I should be able to come to you at any moment,
right.
But I should never doubt
Yes.
or question your integrity.
You see, that's what then the academy is evolving. We must navigate that perception deftly. We must maintain that respect that ought to be accorded to a judicial officer and to the judiciary. But we must not forget that the judiciary exists as an arm of government to render justice. If we let that ball fall, then we will just be dealing with edifices, edifices that must be viewed in awe. That was the colonial institution of a judiciary. You will recall that just not so long ago, before the Constitution was promulgated, not so long ago, if you passed near a judge, wherever it is you met him or her, you had to bow.
Almost.
And if you didn't, the judge would say, where is this scam coming from? No longer now. No longer the practice. These are human beings who are rendering justice.
But then, Judge,
Yes.
I've got to ask this question. As you're discussing the code of conduct, the hallowed esteem that the public will look at the judiciary, and also giving it access, but also the most important and basic ingredient, trust. Do you think it's important for judges, whenever there's suspicion about your conduct, whether in office, on the bench or outside, that this judge should then rise above everybody else and say, questions have been asked, I want to step aside, out of own volition?
Let me be candid. If that were, I wish that could work. But you are a Kenyan like myself.
Yes.
You know the Kenyan society. Earlier I talked about the ability of ingenious Kenyans to fabricate evidence. If we were to say, that any time a question is raised about the integrity of a judge, then they must step aside. Believe you me, within the next 6 months, you shall have no judiciary. Take it from me. You can take it, I don't want to say to the bank, but you can take it to the village, because that's where justice resides. And therefore, what am I saying? I'm saying if somebody has credible claim of impropriety against a judge, they should step forward. There are mechanisms in the Constitution and the law. They should step forward, present that evidence to the Judicial Service Commission by way of a petition, and they must be ready to prove those
back up the claims.
allegations, because judges also expect justice,
That's
even as they are dispensers of justice.
I posit, Judge, that in this case, if we say that the judges raise the bar and say, you mentioned me, I'll step aside, but then you must prove. And we also raise the bar that if you just come up with frivolous allegations against a judge, the punishment is also severe, because you've impacted on justice of the very many other Kenyans. Then now we are going to have a deterrent of not anybody just gets up and decides, Justice Smokin Wanjala did this and the other last week. No, I cannot just come out and speak against the judge.
As I said, I wish that was sustainable and workable. Raising the bar, if it is sustainable and workable, that you are assuming, therefore, that only where it matters will such allegations come up. But I cannot tell you, as long as a Kenyan knows that if I just say this, that person will be required to raise the bar and step aside. Within 3 months, there will be no Supreme Court, there will be no High Court, there will be no Court of Appeal, and there might be no magistracy. So where does that lead us? No judiciary, no country.
Anarchy.
A state of anarchy, yes.
Yeah, anarchy. Judge, we thank you very much for joining us today. So, in conclusion, paint that picture of, with the academy now in place, let's go 10 years down the road. In 2031, what should you expect from the judiciary?
You should expect a state-of-the-art judiciary that is in sync with society. A judiciary that is not removed from society. You should expect benches from the magistracy to the Supreme Court to be populated by thinking judges and magistrates, by people who are in tune, with the people that they serve. That is the institution you should expect, and that is what we intend to harness through the academy. You should see an institution where all Kenyans will be proud to serve. Just like, of course, I'm looking forward to a situation where people will be proud to serve in the police force or in any other sector, because they are going there to serve the people. So that's the judiciary I'm looking at. That is the academy I'm envisioning.
Thank you very much. We hope we'll be here.
Sure.
And we will see as the progress, as we see more progress. The Honorable Justice Dr. Smokin Wanjala is the judge of the Supreme Court of Kenya. He is also the director of the Kenya Judiciary Academy. He's been here telling us about the future of judicial training in the country. And like he said, it sounds like we are going to have some serious, robust decisions coming out of our courts in coming years. And also some very, very serious cases being taken before the courts. Asante sana for joining us today.
Thank you.
This is the Situation Room, the only way to start your day.